All right, it is 11 o'clock Mountain Time, so I think we will go ahead and begin. Hello, everyone. For those of you that don't know me, I am Lindsay with LiveVox. Thank you all for joining today's webinar, CFPB Debt Collection Rule Announcement, Insight from Legal Counsel, and Operational Tips. We're excited to have an awesome lineup of panelists today, but before we begin, I want to just go over a few quick housekeeping items. To the right of your screen, you should see a panel for questions. Feel free to enter any questions you have throughout the webinar, and we'll try to address them either within our presentation or at the end if we have time. Otherwise, we will follow up with you after the event. Also, this webinar is being recorded and will be distributed after the event in the case that you have colleagues that you would like to share the content with. So with that, I'm going to go ahead and read our legal disclaimer, and then Mark, I'll kick it over to you to begin. All right, so this presentation and the statements of the panelists do not constitute legal advice. We urge businesses to consult with their own experienced legal counsel to independently review the topics covered on today's webinar and independently evaluate any compliance measures you may choose to undertake. So with that, Mark, I'm going to hand it over to you to begin and take us away.
Great. Thank you, Lindsay. So first, I want to thank everybody for joining. We really appreciate your presence here. And just to give you a broad overview of the purpose, obviously, we're going to talk about the new CFPB rules, and we're going to discuss it from two angles. So one angle is going to be the actual rules themselves. We have Joanne Needleman, and she's going to go over the actual rules from a legal perspective. We have Jason Queener with us as well from LiveVox, and he will review the rules from an operational perspective. So my name is Mark Malla. I'm General Counsel for LiveVox. And let me turn over to Joanne. Joanne, can you introduce yourself, say a little bit about yourself?
Sure. Thank you, Mark. And thank you, LiveVox, for allowing me to join this webinar. And good afternoon, everyone. My name is Joanne Needleman. I'm with the law firm of Clark Hill. I'm based out of Philadelphia. And I lead the firm's Consumer Financial Services Regulatory and Compliance Practice Group. It's a mouthful, but we'll get there.
Great. Thanks, Joanne. It's a mouthful, as the rules are a mouthful as well.
They are, Mark. Yes, they are.
Yeah. Jason, can you introduce yourself?
Yeah, good afternoon, everybody. My name is Jason Queener. I lead our business consulting team here at LiveVox. We with our customers and prospects on best practices, KPIs, and perfect examples of the CFPB ruling. So happy to share some insight from our customers in our discussions today.
Great, thanks, Jason. So Lindsay, if we can go to the next slide. And just a little bit of background about LiveVox. So, you know, as a company, compliance is very important to us. We pride ourselves on compliance. We regularly monitor developments such as these new rules. And of course, as you can imagine, we design products that help our customers address their compliance needs with respect to rules such as the CFPB regulations. And we also, you know, the CFPB regulations, as we'll discuss, talk about multi-channel outreach, voice, SMS, and email. And we have tools in place to help our customers address each of those communication channels, as well as compliance considerations. So just a little bit about background about LiveVox from that perspective. So let's keep going. A little background on the rules. So the rules were released, as we know, at the end of October, 638 pages, if I'm not mistaken. And somewhere in the 638 pages, it said somewhere in there that the rules apply exclusively to debt collectors and not to first parties. The effective date of these, and we'll get more into that conversation shortly. The effective date of these regulations is 1 year after they're published in the Federal Register. Joanne, have they been published yet?
Not today, not yet.
Okay, all right. So we got basically 1 year plus a little bit of cushion before they actually go into effect. We've identified a few key elements of the rules. So really, we're not looking to convey all 638 pages and what it says. That would be too ambitious. We're focused in what we consider to be key elements. We've got some additional rules forthcoming in December. Joanne, can you give us a sneak preview on that?
Sure. What will be issued in December will be the model validation notice, disclosures on time bar debt. Those are the two main focus. The CFPB is calling it a disclosure focused rule. They will be critically important to the discussion we're having today. Unfortunately, the way that the rules were kind of laid out, we're kind of starting in the middle of the process. I think it'll be important to look at those rules, Mark, that come out in December, because that is how the debt collection process commences, by sending of initial validation notice, and everything there flows therefrom. So those, stay tuned. more to come.
Okay, so yeah, so we'll have to piece this part of the rules together with the rules that are coming in December to get the full picture.
Correct.
Okay, sounds good. And you know, our philosophy here is, even though we've got a runway before the rules go into effect, it's always a good idea to start preparing your operations now, because there's a lot of considerations and a lot of nuances that go into this.
Mm-hmm.
So let's go to the next slide. And, you know, we talked before about the fact that the rules apply to first parties. Excuse me, the rules apply to third-party debt collectors. So, Joanne, why should first parties care about these rules? Why should, if you're a creditor and you're not doing third-party collections, why should you care?
Well, it's a really good question. Mark, you and I have talked about that a lot. I think, you know, as Mark said, and I will specifically tell you on page 32, the CFPB says specifically that these rules do not apply to first parties. But keep reading down that page, because they also go on to say that the rule is not intended to address whether activities performed by entities that are not subject to the FDCPA may violate other laws, including the prohibitions against unfair, deceptive, and abusive acts and practices that you find in Dodd-Frank under Section 1031. So first parties do engage in debt collection, and to the extent that those activities could otherwise be deemed unfair, deceptive, or abusive, maybe not under the FDCPA, but the Bureau is basically saying if we think that those acts pose risk against consumers, we will look to you, you know, and look at UDAP as a way to make you comply and not engage in that activity. So I think that first parties need to be very, very careful. UDAP has not gone away. And in fact, I think if you read this rule, UDAP is very much alive and well. The CFPB is also going to continue to enforce and supervise. And for those of you that follow the Bureau, they have been very active this year, especially to ensure compliance with the CARES Act. There was a letter just issued by Director Kraninger to various consumer groups who were asking her to pull back some of her guidance on some of the CARES Act provisions that the CFPB had provided. She was not inclined to do that right now, but she did stress that the CFPB is doing what is called prioritized assessments. And it's a way to kind of do supervision without having to be on site. So there's lots of questions and requests going out to all entities about how they are complying, not only with the CARES Act, but I guarantee you about debt collection, which has been a big issue during COVID, and credit reporting. You know, as first parties, you hire vendors, right, to do some of your work. And Dodd-Frank is very specific about saying that service providers, that covered entities must supervise their service providers to make sure they're complying with federal consumer financial law. And so that duty has not gone away by these rules. You're still going to have to, you know, look at your service providers and make sure they're in compliance. And in fact, your examination manuals and modules specifically address your service provider oversight. So that is also alive and well. There is, as we'll start to explain as we go through these rules, you really need to think about, if you're a first party, the new due diligence that you're going to have when you talk with your vendors. There's a whole new set of questions that you're going to need to ask to make sure that your vendors are ready when the implementation period begins, that they are ready to implement these rules and do them in the right way. And we will talk about that. And of course, we can have a whole nother webinar about the election aftermath and changes to the CFPB that we do expect. And I think if you saw Biden's transition team as to who he's put together to select a new director, I think that gives you some idea of the type of regulator that they are looking for. And I guarantee you it'll be somewhere along the lines of a Cordray type director that we saw when the CFPB first opened its doors.
Great, that's really good information, Joanne. So basically, potentially direct exposure through UDAP or some other entrees via the rules, as well as important vendor management, vendor oversight considerations.
Yep.
So yeah, good information. So Lindsay, let's go to the next slide, if you would. So let's look at some of the key elements of the rules to bear in mind. So probably, at least from our perspective, one of the most important headline elements of the rules are the telephone contact limits. Joanne, can you take us through that?
Sure. There was not a significant departure from the NPR to the final rule. The CFPB wants to put in limits of how many times you can contact a consumer by telephone. And what the final rule says is that you can contact a consumer per account 7 times within a 7-day period. You can make 7 attempts to contact that consumer. Once you have made contact with that consumer, you then can only have a telephone conversation with them within a 7-day period. And again, that is pretty identical to what was proposed in the NPR. It only applies to telephone. It doesn't apply to digital channels, which we will talk about. But there is going to be a specific contact limit, and it will be incumbent upon third-party debt collectors to monitor that.
Right, and just to emphasize, you said per account.
Correct.
Excuse me, the rules, right, and I think that's really the same thing the rules say about the particular debt. So the contact limits pertain to the particular debt.
Correct.
So if you have multiple debts with the same consumer, then you multiply the contact limits times the number of particular debts or accounts, correct?
That is correct. That is correct. So if you have 3 accounts, you can make 21 attempts within a 7-day period to attempt to contact the consumer 7 times for each account.
Right.
I know people pull account, I think there was a concern that that's really, if you've got multiple debts, that's an awful lot of attempts. But I think, as people know on this call, Mark, and your experience in talking with your clients, accounts are pooled. And so if you speak to a consumer about account A, more than likely you're going to ask them in that conversation, can I talk to you about account B? Rather than hang up and then try to call them again. So, while the opportunity for a lot of phone calls is there, I think industry-wide, that is not how it's ultimately done.
Makes sense. Let's go to the next slide. So when we talk about, you had said 7 and within a 7-day consecutive period, what are some of the exclusions from that?
Yeah, so first of all, if a consumer contacts you directly, that does not count towards, obviously, the call cap. If a consumer consents, you're on the phone with a consumer, can I call you back? You've made contact. Under the rules, technically, you're not allowed to talk to them again for another 7 days. But if the consumer says, can you call me back tomorrow? Or can you call me back in an hour? That would be outside of the limitation period. What also does not count is if you get a busy signal or there is some reason why the call does not go through, maybe it's disconnected, that does not count to your 7 attempts.
Okay, good to know. So Lindsay, if we can go to the next slide. And I'm going to turn it over to Jason. Jason, we just heard about the rules. What sort of operational considerations should we keep in mind?
Yeah, so the challenge for anyone in operations is going to be that rolling 7 days, 7 attempts in 7 days. It's not 7 attempts in Sunday to Friday. It's 7 attempts over a rolling 7 days. So you really have to have a mechanism in place that keeps track of that knows in the past 7 calendar days, I've made X number of attempts. And you're going to have to really be careful about bringing in multiple channels worth of data into that too, because to Joanne's point, they reach out by SMS. That's not an attempt, but it certainly does count as a communication potentially and a contact. So that sort of thing has to be considered. And the other thing that you have to account for in your strategy and your tracking is those exclusionary efforts, right? So if a customer says, sure, you can call me back Tuesday, I have to have a tool that can say, all right, I can make attempt number 8 or 9 potentially because the customer said it was okay. So that's a new challenge, I think. I think we've all managed with the kind of the cooling off period after talking to a customer. I think everybody on this call has done that to some extent. The new one really is, the new challenge is that rolling 7 days and 7 attempts. And you've got to have a tool in place that can allow you to do that without sacrificing your strategies or shortchanging your strategies by making a blanket policy that may not apply to every customer. So the nice thing about the multi-channel contact attempts at an account level or a phone number level is you're not sacrificing your strategy because potentially I called Joanne 7 times but not Mark. So I think that's the big one. And that's one that really should be, from a technology perspective, something that everyone's tackling right now, because that's going to take a little time to deploy.
Yeah, sounds good. Good information there. Lindsay, can we go to the next slide? Yeah, so let's go to another element of the rules, which are the preferred channels. The rules speak explicitly about this. And Joanne, I'm going to turn it over to you to explain that.
Sure. And I think what's important as we start to go through these rules, so first we've talked about contact limits, and that's important, and we have to keep track of that. We're going to also talk about additional, some people call them restrictions. I call them preferences. So we have to pile all of those, both accounting for limits of communication and preferences of communication, both in time, manner, and place. So one of the first opportunities that consumers have to control the rhythm and flow of how they want to communicate with you is to say that they have a preferred channel. I mean, you could be talking to a consumer and they're going to say, you know what, I don't want you to call me anymore. Just email or text me. Or I don't want you to email me at this address. You have to abide by that request of the consumer. I think that's if there's an underlying theme to these rules, it's about really preference management. It's about giving the consumer what they want, how they want it, when they want it, when you are communicating with them about their debts. And preferred method is a very important opportunity to do that. And let me also say, as we will explain further, those preferences can change frequently. And you're going to have to manage when they change, how they change, and you're going to have to abide by them.
Sure. And you know, combined with the telephone limits, when you have these preferred channels, and we'll see with text and email, it seems like the demand here is to have a lot of good processes and a lot of good automated mechanisms in place to manage all this. Would you guys agree with that? Yeah,
and it has to be instantaneous. I mean, it can't. You don't have time to have your staff going through accounts to see what's the preference du jour. So I mean, you have to be able to pull it up. You have to capture it instantaneously, and you have to be able to access it instantaneously.
Great. Okay, let's go to the next slide. So, Joanne, you mentioned preferred channels. What are the exceptions to that?
Well, this is where it starts to get complicated, and I don't want to go off the rails here. These are when all the questions start to come in. So the concern is that consumers are going to tell you that they want a preferred channel. The question is, what happens if they opt out of the channel, or they tell you they don't want the channel and then they use it again? And that, again, is just another layer of having to manage all these preferences. So a consumer can say, I don't want you to email me. But then the next day, the consumer sends you an email. You are allowed to respond back to that consumer saying, thanks for your email. You know, yesterday you told me you didn't want email. I need to confirm again whether you want email. And you're going to have to go through that kind of dialogue with the consumers to find out at any given moment what's their preference. Let me put a small caveat there. The fact that somebody emails you, unless you get that renewed consent, does not give you the opportunity to start emailing again. You're going to have to really drill down and get confirmation that although I told you a preference of excluding a channel, I'm now changing my mind, and you're going to have to capture that. There is exceptions. I don't know if there's instances where the law requires you to use a certain channel. There could be. I see that a lot in the mortgage space, where you want to, you've signed up for digital statements, and the consumer says, I don't want you to email me. I think you can still send the statements. There's a couple few exceptions, but the question of maintaining and managing consumer preferences, especially when they've changed their mind, is going to be really, really difficult.
Yeah, this will have to be managed very closely, clearly.
Yep.
So let's go to the next slide. So Jason, we've talked about contact limits. We've talked about preferred channels, exception to preferred channels. Talk to us about what speech analytics can do to assist with this.
So, and I want to point out first, there's a lot of questions coming in, and we're going to get to them kind of as we go through the conversation. If we don't, we'll get to them at the end as best we can as well. But Joanne's talked a lot about consent and capturing preference. And I think everybody on this phone call can start to appreciate how important an agent is going to become in this process and the trust of that agent. But I like to talk about speech analytics almost like the way I would talk about taking a kid bowling, right? You want to let them bowl, but you want to put some guardrails up so that ball's not in the gutter every time they throw it. So speech analytics is really kind of part of that guardrail situation. And we'll talk a little bit more about empowering the agents here in a little bit, but this is where you really start to be able to verify and validate every communication you're having with every customer. So you can use speech analytics to hear those exclusions where the customer does say, yes, you can call me back on Tuesday. Or they say, yes, you may text message me. Or yes, I would prefer you email me. All of those things are easy to automate for every single phone call in speech analytics. And that's really the only way that you can tackle this, right? Again, we've all been in contact centers for a lot of time, and I love agents, but putting the sort of power in their hands without oversight is dangerous. So being able to monitor your agents every single phone call, and for those of you that are placing with agencies, doing the same with your agencies is very, very powerful because it lets you reconcile every consent, every revocation, every channel of choice. So I think that speech analytics is going to become a very, very powerful tool over the next few years for customers as they try to manage this more.
I agree.
Yeah, that makes total sense. Total sense. So let's turn to email. So the rules talk about obtaining valid email addresses, and there's three. It's divided into three separate categories of how you obtain a valid email address. Joanne, can you walk us through that?
Yeah, let me first preference that you got to read the rule very carefully. It allows you to email and text. The procedures that the CFPB has outlined are solely for the benefit of the debt collector in case there is a third-party disclosure. What's interesting about this rule is it doesn't really set forth a procedure to get consent to a degree. These procedures, again, are there to prevent third-party disclosure. If you do these procedures and for some reason, your email gets in the hands of the person that's not intended, you can say, well, I had these procedures in place. I verified it this way. Therefore, I'm not disclosing third-party information under the FDCPA, which is a very, very big concern. And really one of the major purposes of the FDCPA is privacy, is to make sure that your debts are not disclosed to a third party. So it's really important to understand that this is not necessarily about consent, which raises the issue again, why should creditors care? Because the CFPB, maybe purposely or not, has not addressed the issue of consent. And I would say to you, people say, oh, can I start emailing people? Well, do you know that you have consent to do it? No, I don't, but the rule doesn't say it. Yeah, but there's something called UDAP. And if you're going to start emailing people who didn't want your email in the first place, I will tell you that's an unfair or abusive practice. So, you got to keep all these kind of terms in mind. So getting back to this, the CFPB is allowing email and is protecting debt collectors from third-party disclosure if you follow certain procedures. So one procedure is that if the consumer emailed a debt collector, use an email address and contact the debt collector about that particular debt, you can say that that is a correct email address to contact the consumer. Or if you're speaking with the consumer and they say, yes, you can email me at this address, that is a proper procedure to say that is the correct email address for that consumer. That works, and that's a process that you need to have in place. and that will, in the CFPB's mind, mean that you haven't made a third-party disclosure, you haven't contacted the wrong person.
Right, and that's based on communications between the debtor and the debt collector.
That is correct.
That's this category.
That is correct. Yes.
And let's go to the next category. Is Lindsay, if we can advance.
Yep, that's the next one. So this is really interesting, and this is where we've had a lot of discussion about this.
And Joanne, just to set this up, so the first one is communications we just talked about between the debtor and the debt collector. This is getting a valid email address based on communications by the creditor.
The creditor, right. So the CFPB has always had this idea that debt collectors and creditors have this like very tight relationship, and some of them do and some of them don't. But certainly creditors, especially lenders who've started a relationship with a consumer from the beginning, from the time of the purchase of the car or whatever, you know, they have a lot of really good information about consumers. So in this process, the creditor could pass along an email address that it obtained from the consumer to the debt collector, and that would be sufficient for the debt collector to use. However, I won't go too much into the nitty-gritty here. It's a process. And basically what we're calling it is somewhat of a handoff letter. Now we see this a lot in the mortgage space. We also see it a little bit in the medical space, where the creditor will send a letter to the consumer saying, okay, we've reached this threshold. We are now sending it to ABC Collection. And we are going to provide them with this email address, which is the email address that they use to communicate with the consumer. But it also gives the consumer an opportunity to opt out. And after a certain amount of time, if the consumer has not opted out, I believe it's 35 days, then the creditor can, you know, then the debt collector can then start communicating with the consumer using the information that it got with the creditor. We believe this is a great opportunity for creditors. It really sets, in some ways, up your vendors for success because you're providing them with a lot of really good verified information. And I think at first blush, it's like creditors are going to be like, why would I want to do that? I would really consider this option with your vendors because I do think it's a good one.
Okay. And then the last category is communications between the consumer and the prior debt collector.
Yeah, this one I don't love, but you know, it could be an opportunity. If a prior debt collector did communicate with the consumer using an email address about a debt, you could potentially use that. You as the next subsequent debt collector could use that email address. And again, if the consumer has not otherwise opted out. But you know, I'm hearing a lot. I don't know how much how much do I know about the prior debt collector? How much do I know about their prior operations? I think this is a difficult transfer, and I think that it needs to be clearly vetted before you rely on information from another company of which you had no oversight, you don't know how they operate, and use their information.
Yeah, so you know, when we talk about the rules from this standpoint, with obtaining a valid email address combined with the channel preferences, combined with the contact limits, again, the theme I'm seeing here is really the need for really good processes, really good accountability. I think you got to be audit ready for these types of things. Probably you could be in a position of proving up that you have a valid email address. You probably want to have a good paper trail, so to speak, you know, for that. All true. Burden of proof could be on the creditor or the third party to prove these things up, I would imagine.
Yeah, I mean, there's a lot, to your point, Mark, processes that are going to have to go in place. Again, you may have gotten the valid email address, you go through that process, and once you start emailing, again, going back to what Jason was talking about, they can change their mind. And you're going to have to, you know, so you went through all of that to get the email address, you start using it, and then either that they want you to use a different one, or they want you to email you at a different time or a different place, or, you know, so there's a lot of technology that's going to have to be in place. And again, it goes back to what we talked about at the beginning of the webinar. These are questions, regardless of whatever procedure you use for email, whether the creditor wants to send it to the debt collector or however you're going to send your accounts to your third parties. These are questions that you're going to have to ask. Having this kind of technology is going to be critical, because otherwise it's going to be unmanageable.
Yeah. So it's a quick time check. We're halfway in. We got 30 minutes left. Jason, you said you've seen a lot of questions come in?
Yeah, so let's knock out a couple of them now, because I wanted, Joanne, you mentioned earlier, but I wanted you to clarify these rulings for the 7 attempts the question was, are those voice only, or do those include digital channels as well?
No, they are voice only. And let me also mention too, which we didn't, and I don't want to get too much in the weeds. What this rule did, what the NPR did not, was say that even if you reach this limit, you have a rebuttable presumption that you did not otherwise violate the rule. So I think you need to be very clear, and when you're monitoring your agencies, you need to be very clear when they start going over, not that they will necessarily violate, but they're going to have to defend themselves to say that their conduct was not otherwise harassing or abusive. And so that's a particular nuance that was changed in the final rule, and I think it's really, really important. Again, I think there's no bright line, and I think you have to be, and there's a lot of talk in the rule that even if you do 6, that still could be harassing depending on the content of the attempts and how often you're doing them. So there's going to be there's always going to be a look back. So the Bureau did not give us a bright line. So you're still responsible for your conduct, even though you may be compliant.
Makes sense. Let's do one more. And I think we touched on this briefly. Let's make sure. So the question is, what if there's a borrower and a co-borrower? So Mark and I go in on a condo together. Can they call me 7 times and Mark 7 times, or is it 7 times for the account?
It's 7 times for the particular debt. So and that's another thing you have to manage. You know, you could have one account and 3 borrowers. It could be a student loan, and it's parents. And so you have to be really careful that it's only, you know, I can't talk to dad, 6 times and mom 8 times. You know, you got to be careful. You got to be really, really careful.
Mm-hmm. Okay.
And I think Mark, I can answer this one, but keep me honest here. Voicemails, whether you leave a message or not, are an attempt.
That's correct.
Oh, definitely. Yeah. We talked about. I think we talked about before. If not, the exception from the count is if there's not a connection. A voicemail would be a connection.
Yep. Absolutely.
Yeah. Okay, Jason, any more you want to take now, or should we keep going?
No, well, let's keep going. We'll grab a couple of these towards the end.
Okay, and feel free to jump in if you see anything appropriate, a question at the right time. Okay, let's turn to text messaging. So there's a lot of content here. Joanne, can you walk us through it?
Yeah, let me try to drill it down. So I think the key overview about text, unlike the email procedures, is text information about telephone numbers that you want to use for text can't be passed down. Unlike email, where it could go from the creditor to the debt collector, or can come from a prior debt collector, with text, it has to come from the consumer. And the consumer had to have either used that number to contact you about the debt and hasn't opted out within 60 days. I'll get to that point in a minute. Or the consumer has otherwise consent. Maybe you're on the telephone and you're talking to them, and you can text me at this number, and they consent. Again, and they haven't opted out or withdrawn that consent in the past 60 days. There is another way to kind of verify telephone numbers for text, and the Bureau has put in this rule that the debt collector can confirm through a complete and accurate database that the number has not otherwise been reassigned. The problem with that proposal is I don't know of a complete and accurate database. The FCC has not put together the reassigned number database. There may be companies out there that say, oh, I can get you the correct number. I'd be very wary of them. So it's an interesting part of the rule that I don't know how applicable it's going to be. We're going to have to they thought maybe by the implementation period, the FCC would have its reassigned database. So I'd be very careful with that. I think the other point to consider is this idea that yes, you can use the telephone number to text as long as the consumer has not either withdrawn their consent or opted out within the past 60 days. Well, that says to me that every time you talk to a consumer, you got to refresh that consent. Otherwise, you're going to have to manage what's the 60 days from the last time I got the consent. That could be a nightmare. So that it's a really important nuance to that again has to be managed, and I don't see any other way to do it other than technology.
Yeah, that really stood out to me because I don't think we've seen this before, where not only do you have to have consent, but there's a shelf life on the consent. And in
That's
this
right.
case, it's a 60-day shelf life. So you can't be complacent about the consent you've got. You really have to manage that very closely.
Yep. Yep.
Okay, let's go to the next slide.
So I think it's
opting
really,
out of, go ahead, yes, please.
yeah, I'm sorry, Mark.
Yes.
You know, when any digital communication that you send to the consumer, if they do consent to email or text, you have to have some sort of opt-out provision. And I think the Bureau hasn't made that very difficult. I think if it's a text, if you say stop, if it's an email, if you say unsubscribed, I think you've satisfied the requirement of providing the consumer an opt-out. But I want to warn people that opt-out, as I say, beware of the opt-out, because it is extraordinarily powerful. As we know under the FDCPA, consumers can, in writing, say to debt collectors, don't communicate with me anymore about this debt, and and debt collectors must abide by that. And I would say industry even abides by an oral request to do that. But when we're talking about digital communication, if a consumer opts out, there is language in the rule that says that a debt collector should presume that a consumer does not want to be contacted by that channel, text or email, for any of their debts. So while a consumer may opt out for debt A, you better make sure that if that consumer has debt B that kind of comes to your agency, you better do a scrub and make sure that there's any prior opt-outs, because you cannot communicate with them about any debts using that channel. I think that's really, really powerful, and much more so than the traditional C&Ds that we see under the statute.
Yeah, that is powerful. And you know, again, we don't want to over rely on agents, but agents in this situation would have the ability to say, hey, okay, are you opting out of this channel and not other channels, and sort of try to position and maneuver so that they allow for some open channel to continue.
I agree, but that is going to be difficult if the opt-out comes in through a text, because you can't, if they've opted out, you can't text them unless they happen to text you back, and then you have an opportunity to clarify, okay, well, you texted me, but you said last week you didn't want to be texted. Again, it goes back to Jason's point. We love our agents. They are an important part of the consumer engagement, but boy, agents are going to have to be retrained, and it's going to be a whole different mindset of how to do that.
Mm-hmm. Okay, let's go to the next slide. Jason, let's turn to you for some operational considerations around all of this.
Yeah, so there's good news, right? I mean, we've talked about how much of this relies on the agent, and one of the things that we haven't talked about, especially when we become more and more reliant on multi-channel because they haven't to date put those restrictions in place, and combining that with the fact that more customers want to talk to us by text or email, you know, we have to start being aggressively proactive with, I like saying, making this the customer's idea. So in your lettering to your customer, say, instead of saying, hey, you give us a call at 800-555-1212 or text us at blah, blah, blah. Likewise, on your inbound IVRs, you know, hey, if you'd rather text an agent right now or chat with an agent right now, press 1. So getting that consent by making it the customer's idea to engage you via that channel is going to be a very big deal. But the important part about any of those strategies is that your agents have to be safely empowered to be able to manage it. So giving them a tool and a desktop mechanism by which they can bring in consent and revoke consent safely with those guardrails again is going to be critical to this process. So the nice thing about this example I'm showing you is they're on the phone with a customer, and every one of their conversations from now till the end of time is going to be, this is an attempt to collect the debt, et cetera, et cetera, et cetera. By the way, do I have your permission to text you? Or do you have our permission to email you at mark@livevox.com? When that customer says yes, that agent should have the power to be able to then give a second level of consent by text. Okay, I'm going to send you a text message right now. Go ahead and confirm you have it. You do that with templated messaging, giving that agent all the power they need to give your customer a great experience, but keeping them in your safety mechanisms, right? So all in a single pane of glass, keeping it extremely safe, but at the same time empowering your agents to make these customers have the experience they're still going to expect to have with the limitations we're now putting on them. I think that's going to be a very, very big deal, Mark.
Yeah, so it's sort of like a real-time capture of all these, you know, different mechanisms that are going on and all these different variables. The more we can capture them in real time, the better positioned you're going to be. Again, if there's an audit, if there's litigation, anything like that.
Yeah, and it's going to have to be a single source of entry. It's going to have to be a single source of data, right? You can't have your email over here, your text messaging over here, and your voice channel over here. That's just not going to work anymore. Your agents have to be empowered across your channels to make immediate decisions that are documented and reportable, right? So if I'm an agent and I click, customer says check, I can text them at this specific phone number. I now have the digital record of that. I now have the voice recording of that. And if I'm smart, I have the speech analytics to back it up in a reporting place as well. And I want to touch base on this real briefly. One person asked earlier, how as a creditor can I monitor an agency doing this? This is a perfect example, right? The reporting's there, and you're going to have to stand up that framework to say, we expect you give us reporting on consent. We expect you give us reporting on revocation. We expect you give us reporting on any attempts outside of those 7 that you're allowed. So all that's going to be a big deal. And again, having that in a single place for all your channels is going to be critical.
Yeah, absolutely. Good information there. So let's go to the next slide. So Joanne, time and place for communications. Take us through this.
Well, this is again another element of preference that you're going to have to manage, and this one can be really complicated. The FDCPA has always talked about time and place in respect to communicating with consumers. But now, you know, the FDCPA was written in 1977. There were no cell phones. There is no place anymore for, you know, don't call me at home or don't call me at work. Well, I'm home today. I'm working. You know, what does that mean? I have my cell phone. You know, I can be in different places. So it's, again, to Jason's point, it's going to take a lot of your agents to really drill down to find what is the correct time, what is the correct place. And as we talked about before, consumers can change that preference. So if they say to you, don't call me on Tuesdays at 8 o'clock, but then next Tuesday at 8 o'clock they call you, that doesn't mean Tuesday at 8 o'clock is good. It means that you're going to have to then re-up what is a good time to call. So it's such attention to detail about time, place, communication that again is going to require your agents to be retrained to really identify what is it that the consumer means about when they want to be contacted.
Mm-hmm. Great. Next slide, Lindsay. Okay, Joanne,
yeah,
exceptions to time and place?
Yeah, the exceptions are pretty simple. You know, obviously if the consumer consents to contact you at a certain time, you can do that. And then there's, you know, permissions. You know, if a court says, if you're a collection attorney or you're in litigation regarding a debt, if a court says, you know, call the consumer on Tuesdays, even though the consumer said, don't call me on Tuesdays, to tell them that the hearing has been continued, you're allowed to do that. So there are a few exceptions.
Okay. Lindsay, let's go to the next slide. This is Joanne, I think this is a new regulation here about the requirement to retain records for 3 years.
Yes, not only retain records, but retain recording of calls for 3
right,
years as well.
Right, yeah.
So this was proposed in the NPR, and it did make it to the final rule. You know, for the FDCPA at the federal level, there was never a record retention requirement. Many states have record retention requirements, and the question becomes, what happens if the state requirements are different than the federal? I don't have an answer to that question yet, and we don't know whether states will ask for certain exemptions, so that's a TBD. But I think what is important is that debt collectors are going to have to retain records, and the requirement is 3 years after the debt collector's last collection activity. Well, to me, that can be refreshed. You know, you could have closed an account and maybe you didn't mark it as satisfied, or maybe it's still being reported on the credit report. Consumer could call you back in a couple years and say, you know, I got a question, or there's still a problem with my account. That clock is now that recording and that documentation is gonna have to be retained. And the same for call recording. I mean, you know, if someone calls you back after an account had been closed, but they have a question or there's a problem, those calls are gonna have to be maintained. So I look at this 3-year deadline as somewhat of organic and really a very fluid deadline that can continue. And I think, you know, you gotta think about getting more cloud storage in order to maintain this information.
Right. Well, hopefully, if your agents are trained well, retaining these calls will help you, because they'll be able to prove up consent, you know, and obviously, you know, the call will hopefully be fairly indisputable about consent, you know, and other elements that, you know, other claims that may come in.
I agree.
You know, and Mark, Georgetta actually brought a question in that was exactly like this, right? This is very, very astute. You're going to have to store your recordings for longer if you're not already doing that. I mean, you're going to have that record of truth out there to support a lot of these claims that could potentially be anecdotal if you don't have that record.
Yep.
Right. And just returning to a point I made earlier, you know, a lot of these situations, the burden of proof is going to be on the caller and, you know, indirectly on the creditor. So when the claim comes in, the burden of proof may be, again, on the caller or the creditor to prove these things up. So these call recordings, these records, you know, very important to have good retention policies in place so that you can prove it up. Okay, let's go to the next slide. All right, Jason, I'm going to turn it over to you at this point.
Yeah, thanks, Mark. So here's the good news. We have a year. I would encourage you all to not wait the year, because some of this stuff's going to take some time. So, you know, number one's the obvious one: be proactive. If you're not a LiveVox customer, if that's not your anticipation, I'd encourage you to reach out to your vendors sooner rather than later to start getting these answers. From an operations perspective, you need to start prioritizing compliance and understanding how that could impact potentially your penetration rates, your depth you go into your files, your staffing. I mean, these are all things that you need to start considering, because they are going to have potentially profound effects. Your strategy to decide if you have to implement a new process, specifically around digital channels that we have to talk about, is going to be a big deal. Making digital channels part of your customer's journey is going to be one of the key elements of success for these types of rulings. If you're limiting your voice channels and your customers are screaming to you, I'd like to talk to you via digital channel, these need to be adoption. And again, in a single source of truth, right? Siloing these channels is a recipe for disaster with rulings like this. Mm-hmm. Next thing, we talked about how important your agents are going to be, and the last two are kind of burying the lead a little bit. Monitoring, reporting, tracking on your agent's performance and your customers' wishes are going to be a critical piece to this. So real-time monitoring, translating your transcriptions into actionable data is going to matter, so that you know, I had 200 SMS requests today. I can go to my analytics and see that I had 200 confirmed transcripts of SMS requests. So those are big. Those are not easy, but they are certainly doable, and there are tools in place that are here. They're built for this. So I mean, there's certainly no excuse. We have the time to get it right. So I think it's something we start now for sure.
Yeah, let me just jump in for a second. So just to build off of what you said, so there's no specific limits on the number of texts you can send. There's no limits on the number of emails you can send. There are limits with respect to phone calls, but you've got to look at this, you know, holistically. So you could be in compliance with the 7 calls within 7 consecutive days, but if you're lighting up someone on their text and you're lighting them up via email, then you still could be susceptible to a harassment claim, because Absolutely. You're in technical compliance. You're in technical compliance, but you know, the whole idea of harassment, you know, is a little more nebulous, a little more subjective. So I think, you know, to your point, this all has to be tracked holistically in one place.
Yeah, I mean, a great example, Joanne mentioned earlier, a customer decides to send you a text message, and you you resolve that, or the text turns into a chat on your website. Okay, you have to have a mechanism in place from a technology perspective to know, I can't call this person anymore for 7 days. And that has to be immediate, right? It can't be next day. It can't be 2 days later. You have to know if Joanne's in the middle of a chat on your website, that outbound calling effort has to stop. So yeah, you're right. A single source of truth is going to be critical in this.
Right. And I think, and content and frequency and even at a digital level is still going to matter. I think that the Bureau has left that wide open for scrutiny. I don't know, is 3 texts a week too much? I mean, I think that text and digital channel evaluation is going to go the way of what we've seen with calls for the last several years. We don't know what is harassing, and it's going to be, unfortunately, on a case-by-case basis. And again, the minute you communicate with someone outside of their preference, I mean, that to me, that's just a recipe for disaster. I mean, I think those cases will happen very frequently.
All right, Jason, I think you got it from here.
Yes. So Mark, I think we have, Mark and Joanne, we have a few questions here while we have time. So the first one, Joanne, I'm probably going to yield this to you. Can we require opt-out to be in written text, email form, or can they opt out verbally?
The answer is yes to both. You are required in your digital communication to have some sort of opt-out function. But if you're talking to someone over the phone and they say, I want to opt out, don't email me, I want to opt out, you have to treat it as such. And again, it goes back, Jason, if someone says, don't email me, I think you got to drill that down. What does that mean? You want to kind of, you've got to do what the consumer wants, but I think there's also ways to fashion that preference to your benefit. I don't necessarily know if someone says, don't email me verbally, that is an opt-out. I would want to drill that down to make sure, email me ever, for all accounts, today, next week, there's going to have to be a lot of finessing to ensure that you're doing what the consumer understands what it is that they want as far as their preference, and you're recording it.
So this question came up a few times, actually. Are we considering leaving a voicemail, a contact, resulting in that 7-day cool off, or is that still in your estimation an attempt?
So we didn't address this because it's a small portion of the rule. There were, I think, email and text and frequency were more important, but the Bureau did finalize what is called the limited content message. And I know many of you on the call have dealt with the Fodies and the Zortmans of the world and leaving messages. So the Bureau has said that you can now leave a limited content message. It outlines that you can leave the business name. You have to say, call Susie at this time, and Susie has to be available. And if you comply with their requirements, then that is not a communication, but it is an attempt. And it only applies to voicemail. It does not, you can't leave a limited content text. That is just not part of the rule anymore.
Great, that makes sense. Thank you. So let's to reaffirm this question. If a debtor communicates to us first through an email, does that confirm opting into email?
Yes, if it's about the debt. If they're communicating with you about the debt using an email address, that is consent, yes.
Okay, let's see if we have time for one more here, Lindsay, before I send it your way. And again, Lindsay, I know we have some questions we're probably not going to get time to get to, so we can probably follow up if we need to on this. Let's see, okay, so let's confirm this one more time. The 7 calls in 7 consecutive days is a rule for third-party collections, not first-party, correct?
That is correct, but let me preference. That is not to say that if a first party called within 7 days and in each of those calls, maybe they said some profanity, maybe they said something horrible, those calls could be unfair, harassing, or abusive, or deceptive. So yes, I think from a technical legal standpoint, the frequency limits do not apply to first parties, but that does not mean first party conduct would not be applied elsewhere.
That makes sense. Before I pass it back to Lindsay, Thank you, everybody, and Mark and Joanne. Thank you so much for your time today. Lindsay, I'm gonna turn it over to you.
Awesome. Yes. Thank you, Jason, Mark, Joanne, for all joining today. This was a great panel, and thank you all again for joining today's webinar, CFPB Debt Collection Rule Announcement, Insights from Legal Counsel and Operational Tips. Be on the lookout for an email with a copy of the recording as well as the presentation. And also stay tuned and look out for additional webinar invites in the next couple of weeks. We plan to do a follow-up webinar on the debt collection ruling once the disclosure piece has been announced. So again, thank you all for joining today's webinar, and I hope you have a great rest of your day.
Thank you.
Thank you, guys.